Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Today we are going to discuss a judgment given by the Honorable Apex Court regarding the dying declaration. The issue is whether the dying declaration can be relied under section 498 to prove 498A, whereas the case ended in acquittal as regards 304B of the Indian Penal Code. You all know 304B is dowry death, 498 is harassment. Maybe for additional dowry, harassment or cruelty, 498A. Just these little words, they made the difference. Therefore, interpretation has become necessary. Right? Actually, this is a case relating to Surendran versus State of Kerala in Criminal Appeal number 10GIT 1080 by 2019, which was disposed on 13th May 2022, very 2 days back, by the 3 judges bench, including Honorable Chief Justice of India, Justice Nuthalapati Venkatramana, Sri A.S. Bopanna, and also Madam Hima Kohli, who recently worked as the Chief Justice of High Court of Telangana. This judgment was delivered by them. Now, we will go into the facts of the case. Better to know the facts of the case. Here, Mr. Surendran is the appellant in this particular case. He was married to the deceased on 9/4/1995. Their marriage took place in the year 1995. So, on 9/4/1995, she got married and she left her parental house to the maternal house to lead happy married life or family life. She came to the in-laws. She was leading the life, but after some time, trouble started between them and the appellant, Surendran, along with his mother and others like his sisters, started harassing her for getting additional dowry from her parental house. And of course, she knows the position of her family. So she could not actually ask her parents to bring more or additional dowry. So she could not respond to them. This is the main problem. Ultimately, unable to bear the so-called demand and harassment or cruelty for the dowry, she made an attempt to kill herself on 11/2/1996 by taking some powder, benzoyl hexide powder, they said. So she has consumed some powder and she was admitted in the hospital Palakkad. She was admitted. Luckily, the doctors treated her well. She survived. And later, negotiations or mediations or family consultations between the elders of the family that took place. Ultimately, it is agreed that the appellant would not harass her and that she has to lead marital life. Poor woman, gullible, innocent woman, she believed them. And once again, the deceased started living with the accused and his family members. Do you think that they will keep quiet? No. The harassment continued. Ultimately, after 8 months, unable to bear the harassment, now she committed suicide by hanging in the house on 21/10/1996. Just 8 months. So, her is a troubled family life. So, definitely there were differences between. Right. So, as far as the case is concerned, police booked a case under section 304B of the Indian Penal Code. You may be knowing what is 304B. What is 304B? Suppose if any woman dies within 7 years of her marriage and just prior to her death, if she was subjected to demand for money or demand for dowry, then it is called a dowry death. What is the use of this section? Yes, this dowry death definitely will be useful as the burden of proof shifts to the accused. This is the advantage. 304B and 498A also they have. The case was registered into section 304B, IPC and also 498A of the Indian Penal Code. Why 498A? Because previously she has been subjected to the cruelty, she has been subjected to harassment, and she informed the same to her mother. She became PW3 in this particular case. Right? So the trial went on. The trial court was satisfied and convicted the accused under section 304B and 498A IPC. So that is Surendran, his father, his mother and sisters, they were convicted. Right, so as usual, they went in appeal before the trial court, before the higher court. Of course, higher court also, actually, they have partially modified and they have filed a revision petition. Let us come back to this. So, the appeal was before the Honorable High Court of Kerala. Right, so High Court of Kerala was satisfied that the material against 304B, under 304B, was not proved against the accused. Therefore, they acquitted the accused under section 304B. But relying on the dying declaration given by the deceased made at the time of the so-called 498 harassment case, yes, they convicted the accused. Of course, 498, maximum punishment 3 years, they convicted him for 1 year. So, even he was not happy with that 1 year conviction. Ultimately, he approached the Supreme Court. Now, the legal point is whether when the main case under 304B is acquitted against the accused, can he be convicted under 498A? That too, basing on the evidence, that is dying declaration. Of course, you all know the word dying declaration is attributed to section 32 of the Indian Evidence Act. But please remember, there is no such word by name dying declaration anywhere in the Indian Evidence Act. But normally, we know section 32, it deals with the statements given by a person who is dead or the person who cannot be found. Definitely, they are relevant. This is an exception to hearsay evidence, you all know. So, very famous case was Pakal Narayan Swamy versus King Emperor 1939. And very recently, Ilangovan versus State of Tamil Nadu 2020, and another case that is Paramananda Ganga Prasad versus Emperor 1940. In all these cases, yes, if death is in question, if there is evidence given by him just before his death, it is sufficient. Yes, she has narrated her woes in the shape of dying declaration. Coupled with, please remember, the evidence is supported by her mother, PW3. So, when the DD is there and the supporting evidence of corroborative evidence of PW3 is also there. So, basing on these 2 points, yes, the Supreme Court held that it will not interfere with the judgment given by the Honorable High Court of Kerala, because yes, they have assessed very correctly. So, please remember, this is the beauty of the judgment. 304B, case acquitted, no doubt, okay. 498A, yes, since she has given a statement or dying declaration during the early period, that is on 2nd month of 11 to 1996, and it is corroborated by her mother. So yes, definitely, Supreme Court also said they will not interfere. No. Now you have to hear the arguments on behalf of the appellant, that is Surendran also. They said, the advocate on behalf of Surendran, he says that, Your Honor, already the main case, that is 304B, it ended in acquittal. And secondly, dying declaration, when it is given in the February month, later she survived and subsequently she died. So it is hit by section 161 CRPC. It will be taken as only as 161. But court did not agree. If the instance relates to the cause of death of the person, no doubt she died for the second time, but first time also she made an attempt on her life. She wanted to die. So that itself can be taken as a dying declaration, supported by the evidence of the mother. So the advocate on behalf of the appellant says that the dying declaration cannot be taken into consideration because it was a delayed matter about 8 or 9 months before the death has taken place, it was given. Number 2, the version of the mother of the deceased, it is also having so many contradictions. But court said, material contradiction, they will rely only on the material contradiction. No doubt, with the passage of time, normally we tend to forget so many facts. But if the witness stands on the material facts, itself is sufficient. So court is satisfied with the evidence of the mother as well as the DD of the deceased woman, and ultimately the conviction under section 498A awarded to the appellant Surendran is allowed. So already he is in bail, he is on bail. He was asked to surrender before the court, and he has to undergo 1 year imprisonment in jail. Very good judgment. Please read it, and definitely you will enjoy and you will enrich the legal knowledge. Thank you very much.